One of the most important questions in relation to the DWI charge is, what impact does this have on my license? How am I going to get my driving privilege back? For any person that is charged with a DWI that registers a .08 or above blood alcohol concentration on the intoxilizer at the station by breath, or that refuses to perform the breathalyzer, that person's license is going to be immediately revoked for a 30-day period, what's called a 30-day civil revocation from the date of offense. If there was no refusal and a blood test was performed, then there will not be an immediate 30-day civil revocation. One could come down the road when the results of the blood come back. But if there was a refusal or a .08 or above blood alcohol concentration, there will be that 30-day civil revocation. That civil revocation, in order to get that lifted, there has to be a $100 fee that is paid to the clerk's office in the county of the charge. And so that $100 would have to get paid immediately to the clerk's office, and then the 30-day civil revocation will be lifted upon a payment of that $100 and upon the passing of 30 days. But that is a very important thing to pay, and I would pay that immediately or as soon as possible, even potentially before the 30-day period has run. Go ahead and pay that 30-day civil revocation fee. As a result of the revocation, there is a potential to have, during the final 20 days of that initial 30-day revocation period, what is called a pretrial limited driving privilege. So again, that revocation occurs before there's been a conviction of the DWI. So pre-trial, there is a 20-day period where you can get a limited driving privilege, which is a court-ordered. It's a piece of paper that is given that allows a person to drive for very particular circumstances. So for work, school, what are called household purposes, so errand running, for an alcohol assessment and treatment, and also for community service. All of those would be included as potential reasons for driving under the limited privilege, and it's territorially restricted, certainly within the confines of North Carolina, but can be even more restrictive territorially than that, depending on the judge's decision that is signing the limited driving privilege. Most of those limited driving privileges that are signed pre-trial have to go in front of a judge after requesting a hearing in the clerk's office. So you'd have to go into the clerk's office and request a limited driving privilege hearing, and then you would at that point be able to present that privilege to the judge. If we're retained on a DWI case, that is included in our fee, helping somebody get the pre-trial limited driving privilege. Another form of suspension that can take place is as a result of a refusal. If somebody has refused a chemical test, blood or breath, and that refusal is reported by the officer to the DMV, that person's license will be revoked for 1 year for the refusal, and there is notification of that refusal revocation from the DMV by mail. It is possible to appeal that revocation, so somebody that is going to be revoked for 1 year for the refusal can appeal that decision with the DMV, and that has to be done within 10 days of the effective date of the letter from the DMV stating that the license is scheduled to be revoked for refusal. It has to be sent within 10 days of the date of the letter. If it's sent untimely, then really you're out of luck. There's no way to really get around that 10-day appeal period. There is a possibility of filing a lawsuit that could get around that. It's very difficult if you don't appeal timely to have that appeal heard. If you do request an appeal of the refusal revocation, then your license would stay active pending the outcome of that hearing with a DMV hearing officer that would make a decision about whether there was a refusal or whether there was not. So the license would remain active pending the hearing. Any person that is convicted of a DWI will lose their license for some period of time. If it's a first offense, then typically it's a 1 year revocation. That's not always the case, but typically there would be a 1 year revocation of the person's license for a DWI, and during that period it is possible to get a limited driving privilege depending on the circumstances. If there's no priors, that makes it pretty likely that a person would be eligible for a limited driving privilege, but it also is dependent on what the person's alcohol concentration was. If it's a 0.15 or above, there could be a waiting period as well as an ignition interlock required. An ignition interlock system, which is a system that is installed on a person's car to blow in to activate the car to get the car started. That could be required if there's a 0.15 or above blood alcohol concentration. But as soon as we sit down with you, we'll look at what options you have as far as limited driving privileges and let you know when you're going to be able to get your license back.